David Korman, good to be back with you.
Always good to be with you. We get to talk a little law today, which is always fun for me.
I enjoy these conversations too, and I'm sure our listeners do as well. We're very, very privileged to have you on and to be able to dissect some of these situations.
Yeah, well, some of the busiest lawyers in recent years have been litigation lawyers because there's been so many transactions that have not closed for one reason or another, and we're starting to get, decisions now in some of these cases. And so it becomes interesting on what happens and what people's rights are when deals go bad. And you and I always like to be positive. Like, our whole emphasis is, we want deals to close. And that's the focus in our law practice. Like every transaction we get, like we're just, regardless of that there's issues that come up along the way, our folks always find a way to get it closed and keep it out of the courts, wherever possible, because it's never a good result for anybody if things go to litigation. But today we're going to talk about a case that went to litigation, and it's sort of interesting. So should I go through some of the facts of the case?
Yeah, no, absolutely, David. Take us through it.
Okay, so this was a case, and it goes back. It started in 2019, like 6 years ago. They signed an agreement of purchase and sale, and um, it's a church selling a property in Cochrane, Ontario, and like it's not a big transaction. I think the purchase price was like $65,000 or
Yeah,
something
six,
like that. It
I
was,
think 65 or 58,000 from what I.
yeah, like it was a small purchase price, a $9,000 deposit. Like it's not a big transaction. Anyways, the parties are moving towards closing now, but the buyers in Toronto, their lawyers in Toronto, the properties, out of town. It's a few hours away. Everything was exchanged. Money was exchanged. Documents were exchanged. They're ready to close. The one thing that wasn't exchanged were keys. And there was nothing in the agreement of purchase and sale in a schedule or anywhere that specifically referred to the keys or how the keys are going to be delivered or anything. And this issue comes up like late in the day, like, where are the keys? And it turns out the keys were in Toronto, and the keys couldn't, there was no arrangement there was keys that were being, I think the seller was arranging to leave the keys at a convenience store near the property or something like that, which is hours away from where the parties were and where their lawyers were and everything. And like, go pick up the keys. And the buyer said, no, I want the keys delivered to me. And we're here in Toronto. My lawyer's in Toronto. And so it was a late in the afternoon call where they said, no, we want the keys here. There had been previous correspondence between the parties, requisition letter, all the normal stuff, and there was nobody focused on or agreed to how the keys were going to be delivered. So the plaintiff, or the buyer, ultimately decides not to close. It says, seller, you're in breach of the agreement because I'm entitled to vacant possession, delivery of keys, and you didn't give me the keys. So if I don't give you the keys, then I don't really have vacant possession because you've got the keys and you didn't deliver the keys. It was bizarre. And the judge, when he issued his order, like, he doesn't even start with the facts of the case. He says, this is a terrible case to go to trial 5 years later, and they couldn't find a way to resolve this thing, and they had a fight over an issue like keys. And then over the 5 years, they couldn't even figure out a way to resolve this thing, and it had to go to court. So, you know, pretty bizarre case. So, first thing, David, I know most transactions I see when your agents are doing it, there is a specific paragraph that you put into the agreement of purchase and sale that deals with keys, that says that keys will be left in a lockbox, these keys will be delivered or something, but not be silent on the issue, right?
That's something that we implemented during COVID, and it was a key change. I don't think we really had or we really addressed the key issue before COVID, but COVID was an interesting time for our profession because I feel like a lot of these issues were being addressed now in writing in the APS so that we could facilitate um, uh, virtual closings. And it all happened very quickly and it came together very quickly. So yeah, we do have a clause about the exchange of keys right in the APS now.
Right. So, and that's what the judge sort of found here. He says this wasn't a breach of a provision in the agreement because the agreement was silent on it. So the non-delivery of the keys wasn't a breach of the agreement. He said it was more of a misunderstanding, because the keys are 8 hours drive away from the property. And the seller said, we'll send it to you overnight, which I think they in fact did, and they sent it, to get there the next day. We can extend to the next day. So, but none of that was good enough for the plaintiff, who was saying, no, no, we're entitled to keys and we're terminating the transaction. So it was bizarre, and it was just amazing that they ended up having a 2-day trial over this 5 years later, to get something like this resolved. Who's entitled to it? Now the property got resold, and it was sold for more money, $15,000 more. So the judge goes through it all, and he says, well, what were the actual damages? Because the church was saying, the church as the seller was saying, you know, buyer defaulted, didn't close. We're keeping their deposit money. We had to carry the property, we had to insure the property. We had to do certain things. We incurred expenses and everything. So, and then we resold it. So the judge looks at that and he calculates all their expenses and all their costs and everything. And he says, well, that's $15,219 that the church was sort of out, but you sold it for $15,000 more. So you got your money. So you're only out $219. So the judge says, I'm giving you a judgment for the $219, like 5 years later. And he orders them to repay the money because they got the full closing proceeds from the original buyer. So he orders them to repay that money back to the plaintiff because they sold the property. And so the original buyer gets their money back. The seller resold the property at a decent price, was only out $219. So the judge says, you get your $219 back. Everybody is made whole, but they both lose, right? Why, David? Why did they
Well,
both lose?
they've been litigating for 5 years.
Right,
There's trial costs, there's legal expenses, there's opportunity costs, there's energy wasted, I could go on forever, right?
right, right. So the original buyer gets their deposit money back. They get the balance due on closing back. And they get interest back on their money. And the church ended up, selling it at a price and got their $219. That's the way it worked. But how much did they spend to litigate this 2-day trial? 5 years later, when there was motions and everything, both sides paid a lot of money because they couldn't resolve an issue like this and figure it out on their own. So interesting from that point of view, which reinforces my position. Like, litigation should be avoided at all costs. Like, there's had to be, you think there'd be more reason in the parties in negotiating something and saving that, because at the end of the day, I'm sure both of them, walked out of the court feeling like horrible 5 years later. And all I got to pay my lawyer, for doing all this, right?
So Dave, what are some of the lessons there for our industry? Like what can realtors extrapolate from these rulings?
Yeah. Well, the biggest takeaway from this one is there should be, the keys should be addressed in the agreement of purchase and sale, like you do. And like before COVID, the standard practice was that keys would be delivered on closing
Right.
by the seller's lawyer to the buyer's lawyer's office. Okay. And that would be the norm. Now, in this case, that may not have been very convenient, or maybe it would have been convenient because, the property is 8 hours away from the buyer's lawyer. But the buyer would have loved the keys to just be delivered to their lawyer because the buyer's in Toronto, their lawyer's in Toronto. So that's great. Sometimes a buyer would say, no, I don't really want the keys in Toronto. I've got somebody near the property that'll pick up the keys. I got an agent up there. I got a property manager or whatever. And they might make arrangements to leave the keys there. but usually they would make those arrangements. Um, but it's better to have something in the agreement of purchase and sale that says what's going to happen to the keys. And like you stated, David, since COVID, the norm in the industry has not been to deliver keys to the lawyers as part of the closing documents, but to leave the keys in a lockbox at the property. So if your agreement says we're going to leave the key in the lockbox, in this case, the plaintiff, the buyer wouldn't have liked that. He didn't want the keys at the property. He wanted it in Toronto. Okay. So, but he could have negotiated that or arranged for that or asked for that. And if the agreement was signed on it, the two lawyers could have come to terms on that well in advance of the closing to make sure what the arrangements can be. You want the keys in Toronto? Great. We have time to get them in Toronto. You want the keys of the property? Great. We have time to arrange that. But they didn't do either. Nobody raised the issue till the last minute, before registration on closing, after the money was even delivered. So
Right.
there was a failure on the agent's part, I think, for not putting it in the agreement, addressing with keys. And I think there was a failure on the lawyer's parts too, for not picking up on this issue earlier than at 4 o'clock in the afternoon on the day of closing. So they could have come to some sort of agreement what to do with the keys.
And even the litigation lawyers, like who would advise their clients to litigate over this? You basically say, hey, listen, my fees are going to be more substantial than, the amount that we're litigating over. Like
Right.
it was just silly. And the other thing is, for the real estate lawyer on the seller side to keep the entire proceeds of the transaction,
Right.
and then resell it to
Right.
another party, like that's highly punitive.
Right.
Can you imagine if you're a buyer and you say, hey, I'm gonna, give you the funds, the entire funds of this $1 million house.
Right.
And then the seller says, "Oh, okay, I'm gonna keep that as liquidating damages and resell the property for more money to somebody else, and I'm gonna keep your money in escrow for 5 years until we go through trial." Like that's highly punitive as well.
Right. Right. And I think the fact you're 100% right with that, dude. I think the fact that the dollar amounts were so low, like it was a
Oh,
68,000 purchase, so people weren't focused on that.
right,
But what if it was 680,000, or what if
right,
it was 6.8 million,
right.
and it was delivered on closing because they're moving to closing? We delivered it to the other lawyer. Now they're going to keep that money thinking they're
Yeah.
entitled to it. Like there's no way in the world they're going to be allowed to keep that
No way
money.
in
So
the
you're
world.
right. They have to get some advice from the litigation lawyer at some point. Like a judge is not going to allow you to keep that money. Maybe maybe a judge will say you can keep the deposit money
Yeah.
or some of it, or enough to cover some of your expenses, if the judge agrees that they didn't have the right to terminate the agreement over the keys, if it was a substantial enough issue. But to keep the whole thing,
Yeah.
like
Somebody
this
has
just
to look
got
at that,
stupid.
David, because like even the Law Society, right? Like what would your office do in that situation if somebody, wanted to buy a property and wired you the entire funds, but then said, hey, don't register because we have an issue, we're not closing. And I know you're undertaking to keep the funds in trust, but like in what world do you advise anybody to keep those funds while you go through a litigation process?
Yeah. I don't think we would have done. Look, obviously, we'd have referred to a litigation lawyer who may have done things differently. But my initial position would be, no, we think you don't have a right to not close over the keys. There were enough arrangements that could have been made, reasonable arrangements, and it's not a breach of the agreement. So we're going to keep your deposit money. We're going to
Deposit.
sell the property. We're going to keep the deposit. We're going to sell the property. We're going to reserve our right to claim damages because it might be more than the $9,000 deposit. Turned
Hmm.
out it was 15,000. But I don't think it gives them the right to hang on to the full proceeds
Hmm.
to figure out, oh, there's $6,000 that's still owing to them because we only had a $9,000 deposit and their expenses were 15. So that's their loss. So we're going to keep $6.8 million because we're out $6,000, or,
Hmm.
it just, that was an unreasonable position.
And I was actually going to ask you about that, David, because common law states that if you fail to close, you forfeit your deposit, right?
Right.
Have the courts actually dealt with like the amount of deposit versus damages, or have the courts kind of said, or in common law said that, you forfeit your deposit, And it kind of stops there. Because in my opinion, had they said, okay, keep the $9,000, give us back the remainder of the proceeds, um, that would be a more realistic approach that follows the common law principles. What's
Right.
your take on that?
Well, the judges have some discretion on equitable principles for dealing with it. So you're right, the deposit itself is supposed to be forfeited. But in addition to that, the the seller would have the right to sue for other damages that they incur. Because maybe they sell it for a loss.
Right,
Maybe they can't sell it for 6 months and the costs go higher, the carrying costs go higher. So that's
right,
why you reserve your right and you can sue for those damages. Now, there might be enough of a deposit to cover all of those damages. So then it goes to a judge who can say, no, no, the initial deposit's forfeited regardless, and we're going to make the defaulting buyer pay damages on top of that deposit.
got it.
Okay. But there's equitable principles that jump in. And sometimes the judge says, no, there's enough of a deposit that covers everything. There's no real loss. I don't want to give the seller a big windfall on this. So a judge has some discretion in dealing with that. But usually the defaulting buyer is not going to get their deposit back at all. Now, let's say the deposit was 9,000. Let's say the expenses were only 5. Okay. The judge would say, no, you're still entitled to keep the 9 because they had no right to terminate. So you get the 9 because that's liquidated damages and that you're not getting back just because you failed to close. Now, I'm not going to order any additional damages for the actual 5,000 expenses because they've already got 9 and their expenses were only 5. So they're sort of $4,000 to the good, right?
Got it.
But a judge does have discretion. If they acted in bad faith or something, a judge could say, no, no, you keep the 9 and I'm going to give you an extra $5,000 to cover the actual damages that you suffered.
Got it. Thank you
Okay.
for explaining that. So that
Yeah.
makes more sense. And, I think if they said initially, keep the $9,000, we want the balance of the funds back, I think that would have been a much more equitable situation, and it probably would have held up in court a little bit better.
Yeah.
Yeah. Awesome case. Very interesting, David. Thank you as
Okay.
always for bringing it to our attention. And, it was fun discussing it.
Yeah. No, that's a good one. You can get something as simple as delivery of keys. You gotta be careful in the way you draft an agreement.
You do, and the other big principle here is you have to work with the parties and be reasonable when it comes to some minor misunderstandings. You got to work together and you got to work through these issues, because if they go in front of the judge, the outcome might not be what you expect.
Yeah.
Yeah. Guys, thank you so much for
Okay.
joining
Thank you.
us. As always, if you have any questions, email David Korman, email myself. We'd love to hear from you. And we'll see you guys on the next episode of the David and David on Real Estate podcast. Thank you so much, everyone.